The Competition Act 1998 is the current major source of competition law in the United Kingdom, along with the Enterprise Act 2002. The Act provides an updated framework for identifying and dealing with restrictive business practices and abuse of a dominant market position. One of the main purposes of this Act was to harmonise the UK with EU competition policy, with Chapter 1 and 2 of the Act mirroring the content of Articles 81 and 82 of the Treaty of Amsterdam. Deals with restrictive practices engaged by companies operating within the UK that distort, restrict or prevent competition. These are primarily in the form of horizontal agreements. These agreements could be to limit output, collusively share information, fix prices, tender collectively and share markets out. Competition and Markets Authority is responsible for prosecuting such firms who engage in these activities, and are able to levy fines up to 10% of annual global turnover for every year in which a violation has taken place, up to a maximum of 3 years. Exemptions from prohibition are available if the firm can demonstrate that these practices are in the interest of the consumer through increasing market efficiencies or advancing technical progress. Chapter 2 deals with the abuse of a dominant position by a firm who uses practices such as predatory pricing, excessive prices, refusal to supply, vertical restraints and price discrimination to maximize profit, gain competitive advantage or otherwise restrict competition. In investigating alleged breaches of Chapter 2, a two-stage process is involved. Firstly, it must be identified if the firm actually possesses a dominant market position. This can be done through various concentration indices such as the Herfindahl-Hirschman index. Generally, if a firm is found to have a market share in excess of 40%, then it is considered a threat to competition. There are no exemptions to Chapter 2 as by its very definition as abuse of a market position. One must be guilty of wrongdoing for the chapter to apply. An example of the effects of the Act is that in 2004, public schools were investigated for fee fixing by the Office of Fair Trading. And in 2005, 50 of the leading schools were ordered to raise £3 million between them to be spent on charities nominated by the pupils of the schools involved in the years 2001 to 2003, and were banned from further sharing of information on their external fees.